Hello, Patriots. Welcome to Doug's Democracy Den. Here in the Den, we like to talk about American government, politics, and current events. Every time we visit the Den, we also honor our country and our flag by reciting the Pledge of Allegiance. Please feel free to join in. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Today in the Den, we're continuing our series, Understanding the U.S. Constitution. This is episode 4 in that series. Today we are looking at Article 3 of the U.S. Constitution. Article 3 establishes the Supreme Court. Trivia question. In the last 50 years, there has been one Supreme Court case which is more controversial than any other. That court case is known as Roe v. Wade. What was the final vote total on Roe v. Wade, and on what legal principle was the case decided? I will give you the answer at the end of this episode. The Supreme Court, they really don't get involved in any legal process until the other two have done their jobs. What do I mean by that? Well, Congress obviously makes laws, and the presidency obviously executes the laws. Once Congress has passed a law and the office of the presidency is putting that law into effect, at that point, somebody out in the country might say, hey, that law is unconstitutional. So those two have done their jobs, but somebody else thinks that what they've produced is unconstitutional. They will then take them to court. The role of the U.S. Supreme Court is to be an arbiter. A dispassionate caller of balls and strikes is how some people have put it, like a baseball umpire. They're there to call what is inbounds and what is out of bounds and not care about the outcome. That's their job, like a baseball umpire or a basketball referee. And just like basketball referees or baseball umpires, you only notice them when they make a decision that really outrages a lot of people. That's when you notice the Supreme Court, when they make a decision that ticks people off. So, how does one get to be on the Supreme Court? Very simple process. Whenever there is a vacancy on the U.S. Supreme Court, the President of the United States nominates someone to fill that vacancy. After that nomination process, then the U.S. Senate examines the nomination. They put them through the Senate Judiciary Committee, and then they put them through a vote of the full Senate. And if you pass those two steps, you are on the Supreme Court. It's just that simple. Are there any education requirements to be on the Supreme Court? No, there are not. Anybody can be nominated to be on the Supreme Court. But in our modern politics, obviously, you have to have the best legal education, the best legal experience. That's who they're looking for to nominate. How long is the term? In previous episodes, we said that a U.S. House member serves 2 years, a U.S. Senator serves 6 years. We know that the President serves 4 years. How long does a Supreme Court Justice serve? A Supreme Court Justice serves as long as they want to once they're there. They can only resign or die to leave office. That's their benefit. That's a pretty good gig. Now, in this cycle of them being a dispassionate arbiter, to use the system properly, we expect different groups to follow different protocols. For instance, the pro-marijuana legalization groups have been around the country trying to pass marijuana laws. But you notice what they have not done. They have not just taken a case and gone directly to the Supreme Court and say, we want marijuana legalized. They haven't done that. They've done it the proper way. They have gone state by state and put it on the ballot and had people vote. And then if it votes up, they have their legislation. If it's voted down, they'll come back and try later. They have never taken a marijuana legislation piece and gone directly to court and saying it's unfair that this isn't a law and it should be a law. Some other groups in this country do that. Some other groups bypass you as the voter, and they just take their complaints directly to the courts and demand that the courts give them their rights. That's not how the system works. You're supposed to create legislation, and then the courts are the arbiter of if that legislation is constitutional. Now, to our trivia question. The case was Roe versus Wade. What did the case deal with? The case dealt with the subject of abortion. Is the word abortion anywhere in the U.S. Constitution? Pull up a copy of the U.S. Constitution online and look. You'll be looking for it till Christmas and you won't find it. The word abortion is not in the U.S. Constitution. Therefore, to create the right known as legal federal abortion, the U.S. Supreme Court had to find something in the Constitution to base it on, because they have to hang it on some principle in the Constitution. What the Supreme Court said in their 1973 ruling was that it is a right to privacy issue. They said the Constitution ensures a right to privacy, and therefore that allows you to privately do what you want with your body, including abortion. The Roe v. Wade case is not decided on the concept of abortion, because abortion is not in the Constitution. It's decided on the legal principle of right to privacy. And a lot of people think that that is an incorrect ruling because the judges are in effect creating new law. They're not basing law on what is in the Constitution. What about the vote total? Here's how you remember it. I'll give you the answer. The case entered the court system in 1972. It was decided in 1973 by a vote of 7-2. That's how we got Roe v. Wade. There's Article 3, the courts. Thank you for visiting Doug's Democracy Den.